Hello friends, my name is Dr. Jigisha Singh. In this video, I am going to discuss about capacity to contract. Relevant sections are Section 2G, Section 2H, Section 10, Section 11, 12, 68, 64, 65 of the Indian Contract Act 1872, Section 3 of the Indian Majority Act, Court and Wards Act, General Reference, Specific Indian Specific Relief Act 1877, Section 39, and Specific Relief Act 1963, the new Act, Section 33. Section 2G, an agreement not enforceable by law is said to be void. Section 2H, an agreement enforceable by law is a contract. Section 10. What agreements are contracts? All agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object and not hereby expressly declared to be void. The essentials it mentions is the free consent, parties competent to contract, lawful consideration, lawful object, and not hereby expressly declared to be void. For an agreement to be legally enforceable, one of the essential conditions is it must be made by the parties competent to contract. Who are the parties? Who are the persons that are competent to contract or has the capacity to enter into contract? Section 11 defines who are competent to contract. According to Section 11, all persons are competent to contract except three: a minor, person of unsound mind, any other person who is disqualified by any other law from entering into contract. A minor, like the court assumes that by virtue of his age, he or she is not in a position to understand and appreciate the terms and conditions of the contract, he or she could be easily exploited. Person of unsound mind is provided under Section 12 of the Indian Contract Act. Any other person who is disqualified by any other law from entering into contract, he is also not competent to contract. Such a person can only be a person who is other than the first two mentioned. Now, the example of the third possibility is an insolvent under the law of insolvency. When person is declared by the court as insolvent, he is disqualified from entering into any trade agreements. Now, who is a minor? Section 3 of the Indian Majority Act defines who is a minor. A person less than the age of 18 years is always a minor. That is, as soon as the person attains the age of 18 years, he or she is a major and competent to contract. All persons attaining the age of 18 years ceases to be a minor subject to the following exception. A person for whom or for whose property a legal guardian is appointed before he attains the age of 18 years continues to be a minor till he attains the age of 21 years. That is, a guardian must be appointed before the age of 18 years only, for minors only, or a person the superintendent supervision of whose property has been taken over by the Court of Wards under the Court of Wards Act continues to be a minor till he attains the age of 21 years. As a general rule, on attaining the age of 18 years, a person ceases to be a minor provided the just mentioned two exceptions. Now, who is a person of unsound mind? Section 12 of the Indian Contract Act is the relevant section. A person is of unsound mind if at the time of entering into contract he is incapable of understanding the terms and conditions of the contract and is also incapable of deciding the effects of the contract to his interest. If at the time of entering into contract person is not in a position to decide whether the contract is beneficial for him or not, a person is said to be of unsound mind. The person should be able to form a rational judgment as to whether contract beneficial for him or not. For example, a person heavily drunk, a person running high temperature of 105 degree Fahrenheit. These persons are said to be of unsound mind. Section 12 explains unsound mind as a person who usually is of unsound mind can enter into contract on occasion when he becomes of sound mind. Example, medically a person confirmed a lunatic. On certain occasions he is of sound mind. On such occasions he may enter into contract. A person who is usually of sound mind cannot enter into a contract when he is of unsound mind. For example, a person heavily drunk. Then now we move on to the natures of minors agreements. Nature of minors agreement. The word minor includes the other two, unsound and disqualified by any other law for the sake of convenience. Whether agreement by minor is valid, voidable or void. In UK, ordinarily a minor's agreement is voidable in nature. However, in 3 to 4 cases it is absolutely void. Before the Mohri Bibi versus Dharmodas case decided in the year 1903, in India, high courts were divided and division was sharp, almost 50%. Mohri Bibi case settled all confusion. It was the judgment given by Privy Council. It said agreement by minor is always void, no exception of any kind whatsoever. In UK, agreement for supplies of necessaries of life is an agreement enforceable by law. That is, it is a contract. It is neither void nor voidable. It is a contract which is enforced against the minor personally. They say that if agreement to a minor is void, then nobody would enter into contract and supply necessaries of life to to the minor, because minor can take the plea that I am a minor and there is no contract, agreement is void and I will not pay for the necessaries supplied. In India, agreement for supply of necessaries, such agreement are void, but by virtue of section 68 it can be made enforceable only against the property of such person. There are various statutes also which clearly mentions that minor cannot enter into agreement. For example, the Indian Partnership Act 1932 states that minor cannot made a partner in a partnership firm. The next is doctrine of estoppel. Doctrine of estoppel is provided under section 115 of the Indian Evidence Act. It does not apply against the statute. The doctrine of estoppel is a part of a procedural law, whereas Indian Contract Act is a substantive law. A substantive law is one which creates rights and duties, and a procedural law is one which enables to enforce the rights and duties. In case of conflict between the substantive law and the procedural law, it is the procedural law that fails and substantive law would prevail. If in any case, if we refrain or stop minor from changing his stand from major to minor, it would mean enforcing the agreement as a contract, which is against the spirit of the Indian Contract Act 1872. So if a minor makes a fraudulent statement and induces others to enter into contract, it is void. Next, a minor is not liable even for a tort arising out of breach of contract, provided tort is not independent of the contract. In certain cases, occasions of breach of contract may result in tort. In such cases, minor is not liable even for a tort, because that would indirectly amount to enforcing a void agreement. If tort can be proved only by referring the agreement, minor is not liable. If the minor to be liable, the tort must be independent of the contract. Next, Section 64 and Section 65 of the Indian Contract Act are not applicable to the agreement of minor. Section 64 only in case of presupposes voidable contracts. It is only in case of voidable contracts that Section 64 has applicability. Example, A and B enter into contract. Agreement can be enforced by B only. Such contracts are voidable contracts. Restoration of any benefit received under Section 64 presupposes voidable agreement and not void agreements. Section 65 presupposes a valid contract. Where there is a contract, however, after the expiry of certain period, it becomes void. A person who has received any advantage under such agreement or contract is bound to restore it. Such restoration does not apply in case of agreement by minor, as agreement by a minor is void and not valid. Section 65 presupposes legally binding contract. Now we move on to doctrine of restitution. This doctrine protects the other party and not minor. The minor makes a fraudulent statement against his age. The other party, on the faith of the statement, supplies the minor certain goods on credit. Goods here means movable goods. This doctrine applicable only when agreement pertains to movable property and not immovable property. The goods are in the possession of the minor in the same shape and condition as they were supplied to him by the other person. If the minor is not in possession of the goods, doctrine not applicable. The doctrine does not apply if cash is supplied to the minor. Remedy to other to take back the goods from his possession. The other party cannot claim compensation, as it would amount to enforcing a void agreement. The basis of the doctrine is twofold. No person can be allowed to take the advantage of his own fraud. Goods being identifiable, other party can claim back the ownership. Example, A supplies to M a costly suit length. The same M, the minor, has got stitched. Doctrine not applicable, as minor got the shape of the suit length changed. Example, after receiving suit length, M gives it to C, his friend. Doctrine not applicable, as minor has ceased to be in possession of the goods. A minor can always enforce an agreement which is for his benefit, advantage. Object of the principle is to prevent exploitation of the minor. When benefit is for the minor, he is given the option to enforce it. Other party cannot enforce it, even if it is for the benefit of minor. Other party or any other person cannot enforce it. With this, I conclude. In the next lecture, I would be continuing with the nature of minor's agreement. Thank you.